The 5 individuals who entered the ill-fated Oceangate Titan submersible, which collapsed during its journey to the Titanic wreckage, entered into a robust agreement safeguarding the company from any responsibility for potential incidents involving the vessel.
The deadly Titan accident in the North Atlantic has raised a lot of questions about the craft's carbon fiber hull that failed under 13,000 feet of ocean water.
11 Live's Doug Richards spoke with an engineer and carbon fiber manufacturer today in Paulding County about its strengths and weaknesses.
They signed a massive waiver that lists one way after another they could die on the trip.
An experimental submersible vessel that has not been approved or certified by any regulatory body and could result in physical injury, disability, emotional trauma, or death. Where do I sign?
So none of the 5 people who lost their lives tragically during the expedition were caught off guard. This means they all knew what they were getting into. There are unanswered questions about whether the families can still take legal actions against Oceangate Expeditions, the group that organised the trip to the Titanic, which ultimately led to the loss of all passengers on board. Despite the fact that all the victims who passed away were made to sign a death waiver.
Oceangate itself is contending with more than just multiple investigations, the company facing the very real prospect of lawsuits from the families of those involved.
This event has carved its way into the tragic story of the Titanic, and its memory won't fade away soon. This 3-page document explicitly outlines the hazards associated with travelling in the Oceangate Titan submersible, using striking language that highlights aspects such as the craft's lack of approval or certification from regulatory bodies, and the possibility of being constructed with materials not widely utilised in human-occupied submersibles. The Oceangate Titan submersible experienced a catastrophic implosion while descending, resulting in the immediate demise of all 5 passengers on board, as reported by the US Coast Guard, which led the recovery mission to retrieve debris from the Titan and investigate the cause of the incident.
The ROV subsequently found additional debris. In consultation with experts from within the Unified Command, the debris is consistent with the catastrophic loss of the pressure chamber.
The release of liability agreement lists a number of ways passengers on a trip to the Titanic could die, according to the document reviewed by Insider. By signing the waiver, passengers also gave up the right to take legal action for injury or any other loss. The aforementioned document, given to a passenger in the previous summer, explicitly declares that the signatory would accept complete responsibility for the risk of bodily harm, disability, death, and property damage resulting from the negligence of Oceangate Expeditions during their visit to the remains of the Titanic.
People should know to even get on the boat that takes you to the Titanic, you sign a massive waiver that lists one way after another that you could die on the trip. They mentioned death 3 times on page 1. And so it's never far from your mind. You try and put it out, but as I was getting onto the sub, that was my thought, well, this could be the end. So, nobody who's in this situation was caught off guard. It's very bad things broke this way, but you all know what you're getting into. It's really exploration. It's not a vacation, and it's not thrill seeking. It's not like skydiving or something. These are explorers and travelers who want to see something.
A former passenger on the Titan submersible reveals that you have to sign a waiver explicitly mentioning death 3 times on the first page. This seems to be an airtight death waiver that the ill-fated Titanic sub-tourists were obligated to sign, suggesting that an impending catastrophe was anticipated. However, with the loss of all passengers' lives, will Oceangate Expeditions walk away as if nothing happened? Well, that's not entirely the case. Let's delve into a lawsuit against Oceangate CEO Stockton Rush. In 2023, a couple filed a lawsuit against the CEO of Oceangate Expeditions, Stockton Rush, alleging they were not reimbursed the $210,000 they paid for a trip aboard the Titan submersible, which was cancelled multiple times. These cancellations occurred before the catastrophic implosion at the bottom of the ocean. Mark and Sharon Hagel initiated the lawsuit in February, asserting that Rush had refused to refund the over $210,000 they had spent on an expedition scheduled for June 2018. However, the couple decided to drop the lawsuit following the tragic event of the submersible implosion, resulting in the deaths of Rush and 4 other people on board. In expressing their decision, the Hagels emphasized that honor, respect, and dignity are more important to humanity than money, and extended their condolences to the families of those who perished.
In a statement Fox 35 received this morning, they wrote in part, "Money is a driving force in our economy, but honor, respect, and dignity are more important to the human soul. We wish the entire Oceangate family and the families of those on board the Titan the very best as they grieve the loss of their loved ones."
The question unanswered is if victims' families can sue the company after they're signed the death waiver. You see, waivers protect companies because they lay out the possible risks posed by a given activity or service. A customer must attest to knowledge of such dangers before doing business with the company. And according to experts, the families of the victims might ultimately win a liability lawsuit against the company, since waivers face limitations. The key question is whether Oceangate acted with reckless disregard for safety when it launched Titan on the fatal mission, legal experts said. Richard Daynard, a professor at Northeastern University School of Law who focuses in part on corporate liability, told ABC News that if the company took unnecessary risks and said they were going to do it anyhow, that would be gross negligence. Despite these apparent safety concerns raised with the company, plaintiffs could face difficulty mounting a liability lawsuit, since deep-sea travel carries significant inherent risks and Oceangate has a record of previously completed trips.
They signed a waiver that mentioned the danger of death 3 times.
We're obviously talking about the folks aboard the missing submersible, and Fox 5 legal analyst Wendy Patrick joins us with what liability Oceangate could now face. Good morning to you, Wendy.
Good morning. It's such a heartbreaking story to start us off, isn't it?
Absolutely. And, you know, we're talking about these waivers. So clearly the passengers who were on board understood the risk. And there's definitely an emphasis on potentially there could be death involved if there was an accident.
Yeah, that's true. And is it an accident or is it some kind of reckless, negligent, or intentional conduct? That's definitely going to be one of the very first things that any lawyer representing one of the family members that wanted to sue for wrongful death would have to face. They would have to say, look, it's an ultra hazardous activity. We're not talking about a boat capsizing at SeaWorld. This is a submersible that goes to the bottom of the ocean. And not only that, it's not a company that's been doing this for 50, 60 years. It's a fairly new excursion in terms of the way it's carried off. And it hasn't been without incident even since it's been in business. Remember, there was a 2018 lawsuit against this company by a former employee alleging design deficiencies, basically, and flaws. So whether or not there's legal liability is, as you mentioned, definitely going to matter what that waiver said. But it's also going to depend on if there's a black box or something similar recovered, what that reveals, the story that reveals if, God forbid, the passengers cannot.
Signing a waiver doesn't automatically justify causing harm to passengers on the Oceangate Titan. However, the waiver explicitly outlines the potential risks, much like cigarette companies providing disclaimers on packs. In a similar vein, it's challenging for families of smokers to sue after being warned of the consequences. In the case of the Oceangate Titan, passengers were thoroughly briefed on the dangers through the waiver, explaining the possible hazards of the expedition. Moreover, it's difficult to argue that the company acted recklessly when the CEO was part of the journey. A viable lawsuit would only emerge if it could be proven that passengers were defrauded or if Rush acted recklessly. The submersible was evidently experimental, breaking technological and innovative standards. Passengers were well aware and knowingly signed a waiver, understanding the inherent risks. This situation differs significantly from a regular trip, such as a cruise or modern-day airplane flight. Courts often scrutinise the circumstances surrounding an incident, and if there is evidence of gross negligence, willful misconduct, or actions that go beyond the inherent risks disclosed in the waiver, it could undermine the effectiveness of the waiver in a legal context. In such cases, the waiver may be challenged, and the court may assess whether the company met its duty of care to ensure the safety of the passengers. However, before you go, don't forget to like and subscribe to this channel.